Welcome to Cybersecurity of Medical Devices, Legal and Ethical Challenges. This is the recording of the presentation given by Elisabetta Viesin and Eric Kamenjasevic on 6 July 2020 at the occasion of Cybersecurity Initiative Flanders seminar. That seminar notably proposed two angles of analysis of medical devices cybersecurity. The first, legal, which you are listening to now, and the second, technical, given by Edward Marin, whose presentation is retrievable on Cybersecurity Initiative Flanders website. This presentation concerns the ethical and legal challenges for medical devices cybersecurity. Healthcare cybersecurity is becoming a growing global concern. The last few years have seen an increasing rate of IT security incidents and data breaches for many healthcare ecosystems. Reports show that ransomware and other cyber attacks are on the rise, and that healthcare is one of the key targets. Everyone might recall the WannaCry ransomware that in May 2017 affected more than 200,000 computers across 150 countries. And NotPetya, the ransomware that reportedly in the same year caused more than $10 million damages worldwide. Incidents do not only concern network but also information systems, such as medical devices. Medical devices are, by way of example, insulin pumps, pacemakers, glucose measuring devices, X-ray scanners connected to the hospital IT networks. Their exponential use over the last decade, especially for connected devices, has exposed their vulnerabilities to cyber incidents and attacks. Cybersecurity researchers and experts have raised awareness of how these devices are hackable. For example, a team of researchers at the 2018 Black Hat USA Convention showed how an attacker could cause a pacemaker to deliver a deadly shock, and how an insulin pump could be prevented from delivering the needed insulin to a patient. To mitigate risks to network and information security systems, EU policymakers set up a dense regulatory agenda in the last years concerning cybersecurity, such as the NIST Directive, the Cybersecurity Act, and other proposed legislation. The most relevant frameworks for medical devices and cybersecurity are the Medical Devices Regulation as product-specific legislation, and then other horizontal legislation such as the NIS Directive, the GDPR, the Radio Equipment Directive. These laws set somehow specific requirements for medical devices to be respected. Also, in 2019, the European Commission Medical Devices Coordination Group issued specific guidelines on medical devices cybersecurity. That said, some regulatory challenges remain. First and preliminary, we think that cybersecurity is a term that brought some conceptualization issues amongst policymakers, legislators, and stakeholders. Weak conceptualization imply a lack of coherent terminology. This issue may carry the risk to obstruct coherent regulation in this area, and thus hamper the development of regulatory measures. Secondly, we think that the Medical Devices Coordination Group could address this lack of terminology issues by referring to the new Cybersecurity Act for crucial terms such as cybersecurity, security by design, and by default that have been recently defined by it. That will help in achieving a consistent approach to cybersecurity by member states and ultimately stakeholders. Third, specific regulatory challenges may be envisaged with reference to vertical and horizontal legislation. In particular, we envisage the following challenges. First, a regulatory overlapping between medical devices regulation and cybersecurity certification schemes. Both hacks set security requirements to be certified that might result in an overlap. Second, regulatory uncertainty between the MDR and the Radio Equipment Directive security requirements, as there is no clear rule guiding on the scrutiny thereof. Third regulatory challenge is fragmentation. It is again the Cybersecurity Act and cybersecurity certification, which may provoke divergent mechanisms in the internal market. Fourth, application risks concerning security incident notification for the three different frameworks applicable: the Medical Devices Regulation, the NIS Directive, and the GDPR. Our final part is about the ethical concerns on medical devices cybersecurity going beyond the legal framework. We provided two examples within the framework of biomedical principles by Beauchamp and Childress. The first concern relevant to medical devices cybersecurity is privacy. In the medical context, privacy is pivotal for safeguarding patient autonomy and reducing their status of vulnerability. Medical confidentiality is one of the most important instruments to protect patient privacy. If security incident affects a collective medical devices, it might impact such duty of confidentiality, as it could lead to destruction, loss, alteration, or unauthorized disclosure of patient personal or health-related information. The misuse of data by a third party could cause unjust discrimination or stigmatization of the patient, thus conflicting with the principle of justice. Furthermore, a breach of confidentiality might also affect patient trust towards healthcare practitioners on the one hand and towards the reliability of the healthcare system use on the other hand. If a data breach occurs and the patient data are disclosed, misused, or lost, his or her trust in the healthcare system could be severely undermined. A third and final issue relates to the allocation of responsibility in the connected healthcare environment. The increasing digitalization has brought together several stakeholders in the processing of data. When a wearable technology such as a pacemaker processes personal data, this implies the involvement of healthcare providers, healthcare professionals, the patient, medical devices manufacturers, as well as any other stakeholder who is providing the connected network and information system. If a cybersecurity incident occurs, it might be difficult, if not impossible, to allocate stakeholders' responsibility amongst all of the mentioned above. To summarize our findings and conclusions, ethical and legal challenges of medical devices and cybersecurity remain an open issue. Regulation efforts for adopting a consistent conceptualization at the EU level may determine in future a more coherent legislative framework on cybersecurity. As regards regulatory challenges, we think: first, regulators should clarify how and whether cybersecurity certification should apply to medical devices. Second, the application of the Radio Equipment Directive and the Cybersecurity Act should be clarified to avoid regulatory uncertainty. Third, coordination mechanisms among national authorities should be strengthened to avoid fragmentation on the one hand and application on the other hand. This was a reduced recording of our presentation given at the occasion of the Cybersecurity Initiative Flanders. We hope you enjoyed it. If you are interested in our works, please check out our Twitter account, LinkedIn profile, as well as our staff page on KU Leuven website, where you will find the list of our publication, presentation, posters, blog posts on this matter, as well as on other eHealth reading topics. Goodbye and see you soon.